Ever wondered what happens to your assets when you pass away in Colombia? It's a question that's worth pondering, as the answer lies in the expansive branch of civil law known as succession law. This law governs how a deceased person's property, known as their estate, is transferred to their heirs or legatees, whether through the dictates of a will or the provisions of the law. A deep dive into the Colombian Civil Code, specifically Articles 1008 to 1409, and the General Process Code, specifically Law 1564 of 2012, Articles 487 to 495, provides a comprehensive legal basis for these transfers. So, it's clear that understanding succession rights can be crucial for planning your estate. In the world of law, knowledge is power, and understanding the rules of the game can make all the difference. Did you know there are different types of succession in Colombia? Let's dive into the three main types and comprehend how they impact the distribution of assets after one's death. Firstly, we have the testamentary succession. This type comes into play when the deceased, also known as the testator, leaves behind a valid will outlining the disposition of their assets. This type of succession is governed by the will of the testator, but within legal limits. For instance, the law safeguards the legitimate portion for forced heirs, which cannot be overlooked or omitted by the will. This type of succession is grounded on Articles 1055 to 1070 of the Colombian Civil Code. Secondly, we have intestate succession, or intestato. This occurs when there is no will, or the existing will is invalid or incomplete. In such cases, the law steps in to determine the heirs and the order in which they inherit. This type of succession is based on Articles 1040 to 1047 of the Colombian Civil Code. Finally, we have mixed succession. As the name suggests, it's a combination of the first two types. Part of the deceased's estate is distributed as per the will, and the remaining part is governed by the law. This scenario typically arises when the will does not cover the entire estate, or when part of the will is deemed invalid. In conclusion, the type of succession one falls under can greatly influence the distribution of their assets posthumously. Testamentary succession gives the most control to the deceased over their estate, while intestate succession leaves it up to the law. Mixed succession, on the other hand, involves a blend of personal wishes and legal mandates. Therefore, the type of succession can significantly affect how your assets are distributed after your death. But who gets your assets if you die without a will? This is a question that often comes up when discussing intestate inheritance, or inheritance without a will. In Colombia, the Civil Code outlines a specific order of heirs who stand to inherit your assets in such a situation. First in line are your descendants. This includes your children, grandchildren, and even great-grandchildren. They are the primary beneficiaries of your estate in the absence of a will. Next up are your ascendants. These are your parents and grandparents. If you don't have any surviving descendants, your assets will pass on to them. Following your ascendants comes your surviving spouse or permanent partner. They stand to inherit your assets if there are no descendants or ascendants. Then we move on to siblings and nephews or nieces. If there are no descendants, ascendants, or surviving spouse, your siblings and their children may inherit your assets. Further down the line are other collateral relatives up to the 6th degree. These could include your aunts, uncles, cousins, and even some more distant relatives. Finally, If there are no eligible heirs among your relatives, your assets will go to the state. This is a last resort, and it's not as common as the earlier options. It's important to note that this order of inheritance is strictly followed. It ensures a fair distribution of assets among the closest relatives first. This order can't be altered unless you've left a valid will specifying a different distribution. So, in a nutshell, the law has a plan for your assets, even if you don't. It ensures that your assets are distributed in a particular order if you don't leave a will. But remember, having a will can make the process smoother and more aligned with your wishes. What rights do heirs and legatees have in succession? In the complex landscape of succession law, heirs and legatees are granted a set of rights that help them navigate their inheritance journey. Let's delve into these rights and understand how they impact the process. Firstly, there is the right to inheritance. This is the most fundamental right, granting heirs or legatees the entitlement to receive the assets of the deceased, as outlined in Article 1011 of the Colombian Civil Code. Next, we have the right to accept or repudiate the inheritance. This right, established in Article 1284, gives heirs and legatees the choice to either accept or reject their inheritance. This is an essential right, as it empowers individuals to decide whether they wish to take on the potential liabilities that might come with the inherited assets. Another key right is the right of accretion. This comes into play when an heir renounces their share of the inheritance. According to Article 1230, the renounced portion is then distributed amongst the remaining heirs. It's a bit like a game of pass the parcel, but with a much higher stake. Then there's the right to the legitimate, which is the minimum portion of the inheritance that cannot be taken away from the compulsory heirs. This is covered in Articles 1226 and 1230. The surviving spouse also has the right to marital usufruct, as per Articles 1026 to 1036. This means they get to use and enjoy the inherited property. The right of representation allows a person to inherit on behalf of a deceased descendant, as stated in Article 1041. There's also the right to request partition. Any heir can request the division of the inherited assets as per Article 1323. Last but not least, the right to hereditary possession. Heirs have this right from the moment of the opening of the succession, as per Article 757. These rights are essential to ensure that heirs and legatees can claim their share of the inheritance. But what if you don't claim your inheritance immediately? It's a valid question, and it brings us to the concepts of prescription and expiry in the context of inheritance. These legal terms play a critical role in determining the time frame within which you can claim your inheritance. Prescription is a legal principle that sets a time limit for individuals to claim their inheritance. According to Article 1321 of the Colombian Civil Code, the action of petition for inheritance expires after 10 years. This countdown starts from the date of death of the deceased, or from when the heir was deprived of their rights. Let's make this clearer with an example. Say, someone passed away in 2015. According to the rule of prescription, the heirs have until 2025 to stake their claim to the inheritance. If they fail to do so within this 10-year period, they lose the right to claim their inheritance. Next, we have the concept of expiry. This mainly applies to disputes over wills and the acceptance or repudiation of inheritance. For instance, the action to challenge a will due to formal defects expires after 4 years, as stated in Article 1048 of the Colombian Civil Code. This means that any legal actions against a will must be initiated within this 4-year period. So, you see, While succession rights are designed to ensure a fair distribution of a deceased person's estate, they also come with certain time-bound constraints. Failure to act within these legal timeframes can result in the loss of your right to claim your inheritance. In conclusion, when it comes to claiming your inheritance, time is of the essence. It's not just about knowing your rights as an heir, it's also about understanding the legal timeframes that govern these rights. So, it's crucial to act promptly and within the legal timeframes to claim your inheritance. So how can you ensure your assets are distributed according to your wishes after your death? We've explored the answer to this question by delving into the expansive realm of succession rights in Colombia. We've learned about the different types of successions: testamentary, intestate, and mixed. We've also shed light on the order of heirs, ranging from direct descendants and ascendants to siblings, other relatives, and ultimately the state. Succession rights too pack an extensive array. From the right to inherit to the right of representation and the right to request partition, understanding these rights is crucial. Remember, time is of the essence. If you believe you have a claim to an inheritance, don't delay. The clock starts ticking from the moment of the deceased's passing. By understanding succession rights in Colombia, you can make informed decisions about your estate and ensure your assets are distributed as you wish.